The first warning sign went up 3 weeks before the incident. It was bright yellow, bolted to a wooden post at the edge of the trail that cut behind my property. Big black letters. Impossible to miss. Bear activity reported. Do not approach. No feeding. Use caution. I didn't put there casually. The local wildlife office issued the notice after multiple sightings, and they asked nearby landowners to post warnings because the bears had started wandering closer to homes. I complied immediately. I live near the edge of the HOA boundary, right where manicured lawns turn into trees and brush. That trail technically runs along my land before cutting back toward the HOA walking path. People had always used it unofficially, and I never stopped them, as long as they respected the rules and the risks. Most residents did. Except her. HOA Karen lived 3 houses down from the trail entrance. She was the kind of person who treated posted signs like personal insults. Rules didn't apply to her unless she wrote them. And even then, she revised them depending on who she was mad at that week. The day after the sign went up, I saw her standing there with 2 other residents, arms crossed, laughing. "Bears," she scoffed loudly. "Please. This is a neighborhood, not the wilderness." I told her calmly that the warning came from wildlife control, not me. I even showed her the printed notice they emailed to all nearby property owners. She waved it off and said fear-mongering didn't belong in an HOA community. Then she said something that stuck with me. "If something happens, that's on you. This is your land." That was the moment I realized this wasn't about safety. It was about control. Over the next 2 weeks, she ignored every precaution. She walked the trail alone at dusk. She brought guests. Once, I even saw her toss food scraps into the brush, while loudly insisting bears wouldn't come near people. Other residents stopped using the trail entirely. The sign worked for everyone except her. I documented everything. Photos of the sign, dates it was posted, copies of emails from wildlife control, even timestamps from my security camera showing her walking past the warning repeatedly, sometimes shaking her head like the sign offended her personally. Then one evening, just after sunset, I heard screaming. It wasn't the kind of scream that comes from a disagreement or a scare. It was raw panic. I ran to the edge of my property and saw neighbors gathering at a distance near the trail. Flashlights were flicking on. Someone had already called emergency services. She had encountered the bear. Not attacked, but close enough to send her running, tripping, and injuring herself in the process. By the time paramedics arrived, the bear was gone. Wildlife control confirmed later that the animal behaved defensively, not aggressively. Exactly what their warnings had predicted. I thought that would be the end of it. I was wrong. A week later, I received a letter from her attorney. She was suing me for negligence, for emotional distress, for failure to ensure safety on my property. She claimed the warning sign was insufficient, that I should have blocked the trail entirely, that my land posed an unreasonable danger. She ignored the warning. She mocked it. She walked past it anyway. And now she wanted to make it my fault. That's when I knew this wasn't just an HOA problem anymore. It was going to be a legal one. The moment I finished reading the lawsuit, I stopped being angry and started being methodical. 7 years of dealing with HOA personalities had taught me one thing: emotion loses cases, documentation wins them. And if she wanted to drag this into court, I was going to meet her there with facts, timelines, and evidence she couldn't laugh off. I called my attorney the same day. He read the complaint slowly, then let out a short breath and said something that immediately lowered my blood pressure. He told me this wasn't a strong case, it was a loud one, built more on entitlement than law. But that didn't mean it could be ignored, especially when an HOA Karen was involved. The first thing he asked for was proof. Not opinions. Not character statements. Proof that I had acted responsibly. I gave him everything. Emails from wildlife control warning about bear activity in the area. The exact date they recommended posting signage. Photos showing when the sign was installed. Wide-angle shots proving it was clearly visible from the trail entrance. Close-ups showing the wording was unambiguous. Timestamp security footage of her walking past the sign repeatedly, sometimes stopping to look at it, sometimes gesturing dismissively, sometimes bringing guests with her. We organized it all into a clean timeline. Week 1. Wildlife alert issued. Week 1. Sign installed. Weeks 2 and 3. Repeated documented disregard. Incident day. Encounter at dusk. Exactly the time wildlife control had warned against. My attorney nodded as he reviewed the file. Then he asked a question that made the situation even clearer. Did you ever invite people onto that trail?
No.
I never advertised it. Never encouraged use. Never hosted events. The trail existed long before either of us moved there, but it was never designated as a community amenity. It was simply land people passed through because no one stopped them. That distinction mattered. A lot. Legally, there's a massive difference between maintaining a public recreational space and owning land that people choose to walk through despite posted warnings, especially when those warnings are issued by an official authority. Then came the wildlife report. Wildlife Control provided a written statement confirming that the bear was not aggressive, that signage was the recommended response, and that blocking access could have created more risk by forcing people to detour through denser brush. In other words, I followed best practices.
Exactly.
Meanwhile, Karen's story started falling apart. In her filing, she claimed she had no reason to believe the sign was legitimate. But we had email records showing she'd been copied on the HOA-wide alert about wildlife activity weeks earlier. She claimed she was unaware of bear presence, yet neighbors submitted statements saying she openly mocked the warnings. Worst of all for her case, she alleged that I had a duty to physically prevent access. My attorney nearly smiled at that. Because once you argue that someone should have blocked access to their own land to protect you from a known, posted risk, you admit something critical. You knew the risk existed. And knowingly ignoring a risk destroys a negligence claim. Then the HOA inserted itself. The board sent a letter asking whether I planned to resolve the situation quietly. Translation: they were nervous about headlines, liability, and insurance premiums. I replied through my attorney with a single sentence: all communication would be handled legally. That shut them up fast. Discovery began. Karen's attorney requested my camera footage. I handed it over without hesitation. They requested maintenance records. I provided them. They asked whether I'd ever removed the sign. I hadn't. In fact, the footage showed it standing in place every single day. Then we received her discovery materials. And that's when things turned. Because buried in her own phone records were photos she'd taken of the sign, weeks before the incident, with sarcastic captions sent to friends. One message read, "Apparently we're living with bears now, face with rolling eyes." Another said, "I'm not letting fear dictate my walks." She documented her own disregard. She laughed at the warning. She ignored it deliberately. And now that same sign was the centerpiece of her lawsuit. By the end of that week, my attorney told me something I didn't expect. "This isn't going to trial," he said. "She's about to realize that suing you only made her position worse." And that realization was coming fast. The shift in tone came quietly. There was no dramatic announcement, no sudden apology, no public admission of wrongdoing. Instead, it started with delays. Her attorney asked for extensions. Deadlines slipped. Motions were filed, and then withdrawn. The confidence that had fueled the lawsuit began to drain as the evidence stack grew heavier and harder to ignore. My attorney explained what was happening behind the scenes. Once discovery exposed her own messages, photos, and behavior, her legal position weakened dramatically. Every sarcastic caption and dismissive comment chipped away at the claim that she had been unaware of the danger. In negligence cases, credibility matters just as much as facts. And hers was unraveling. Then the deposition was scheduled. She arrived dressed professionally, posture rigid, jaw tight. I watched quietly as she was sworn in and reminded that she was under oath. Her attorney sat beside her, noticeably more restrained than during earlier exchanges. The questions started gently: basic background, familiarity with the trail, awareness of wildlife in the area. Then the warning sign came up. She claimed she believed it was unofficial and possibly placed as a scare tactic. My attorney calmly pulled up the emails showing the wildlife office notice, including the HOA-wide distribution she had received. He asked if she recognized the message.
She said yes.
He asked if she had read it. She hesitated, then said she skimmed it. Then he showed the photos from her phone, images of the sign taken weeks before the incident, complete with timestamps and sarcastic messages attached. He asked her to confirm whether she had sent them.
She did.
The room went silent. From there, the deposition became less about her injury and more about her choices. She admitted walking the trail at dusk despite warnings. She admitted bringing guests. She admitted believing the risk was exaggerated. And with every admission, the foundation of her lawsuit crumbled further. After the deposition, settlement talks were proposed. Not by us. By her. Her attorney reached out requesting a confidential resolution. My attorney declined immediately. He explained that settling now would only validate a claim that had no legal basis and potentially invite future issues. We weren't interested in quiet payoffs. We were interested in finality. The Wildlife Office added another layer. They issued a formal public advisory restating their previous guidance and confirming that signage, not fencing, was the recommended safety response in that area. They also clarified that individuals who ignore posted wildlife warnings assume personal risk. That advisory landed directly in the case file. The HOA, sensing the direction this was heading, began backing away. Their earlier concern about quiet resolution turned into silence. No public statements. No involvement. No support for a claim. They wanted distance, and they wanted it fast. Then the motion came. Her attorney filed a request to dismiss the case without prejudice, meaning she could theoretically refile later. My attorney objected immediately and pushed for dismissal with prejudice. The argument was simple. She had already abused the legal process once, and the evidence showed no legitimate claim. The judge reviewed the filings carefully. During the hearing, the judge didn't raise his voice or express irritation. He didn't need to. He simply asked a series of calm, precise questions about warning visibility, personal knowledge of risk, and personal choice. Each answer reinforced the same conclusion. You can't ignore a clear warning and then blame someone else for the consequences of your decision. The ruling came down a week later. Case dismissed. With prejudice. She couldn't sue me again over the incident. But the fallout didn't end there. Because losing in court is one thing. Losing credibility in your own community is something else entirely. And that was just beginning. The moment the dismissal became public, everything changed. Up until then, she had controlled the narrative inside the HOA. Quiet conversations, selective storytelling, carefully framed complaints. Most people had only heard her version, that she was injured due to negligence, and that someone else had failed to protect the community. But court records don't care about spin. Once the case was dismissed with prejudice, the documents became accessible. Neighbors started reading the judge's reasoning. They saw the exhibits, photos of the warning sign, the timestamps, the emails from the Wildlife Office, and her own messages mocking the danger. And just like that, sympathy evaporated. People who had avoided eye contact with me before started asking questions. Not confrontational ones, curious ones. The kind that come when a story doesn't line up anymore. I didn't embellish or celebrate. I simply told them the truth and let the paperwork speak for itself. The HOA board was next. At the following meeting, the atmosphere was tense. This was the same board that had quietly encouraged her early on, hoping the issue would resolve itself, without conflict. Now they were facing something far worse. Proof that one of their most outspoken members had knowingly ignored safety warnings and then tried to shift responsibility onto others. A board member asked, on record, whether the HOA faced any liability exposure from supporting her claims. The association's attorney didn't sugarcoat it. He explained that while the HOA wasn't named in the lawsuit, continued public alignment with her position could invite scrutiny, especially since the HOA had properly distributed the wildlife warning and documented it. Any attempt to minimize or contradict that would undermine their own compliance record. Translation: distance yourselves now. Within days, the HOA quietly updated its safety policies. The bear warning signage was expanded. A written acknowledgement was added to community bulletins stating that wildlife advisories must be followed and that residents assume personal risk when ignoring posted warnings. Her name wasn't mentioned. It didn't need to be. The social consequences were immediate. Invitations dried up. Conversations stopped mid-sentence when she walked into common areas. The same confidence she once carried was replaced by sharp glances and forced smiles. In a community where reputation mattered, hers had taken a direct hit. Then came the final twist. She attempted to file a complaint with the HOA, claiming that the expanded warnings were retaliatory and designed to embarrass her. The board rejected it unanimously. The response letter was brief, factual, and devastatingly neutral. It cited the court dismissal, the Wildlife Office advisory, and the HOA's obligation to prioritize safety over individual feelings. No appeal process. No discussion. That letter circulated faster than anything else. By the end of the month, she resigned from her HOA committee role. No announcement. No farewell message. Just a quiet removal from the roster. I didn't celebrate. I didn't need to. Because the lesson had already landed, not just for her, but for everyone watching. Warnings exist for a reason. Responsibility doesn't disappear just because you don't like the message. And courts don't reward people who ignore clear danger and then look for someone else to blame. What started as a lawsuit ended as a cautionary tale. And the final chapter made that unmistakably clear. Time has a way of settling things that arguments never can. Weeks after her resignation, the community felt different. Quieter. Less tense. The constant undercurrent of complaints, emergency emails, and dramatic confrontations faded into the background. People started using the trails again, this time carefully. Families actually read the posted notices. Kids ask their parents what the bear signs meant instead of treating them like decoration. The warning did what it was always meant to do. Ironically, her lawsuit ended up strengthening the very system she tried to undermine. The HOA worked more closely with wildlife officials. Trail cameras were installed near high-risk areas. Educational bulletins went out explaining bear behavior, seasonal risks, and exactly why human negligence makes encounters worse. No one wanted a repeat. As for her, she didn't move away. At least not right away. But she changed. The bold confidence was gone. She avoided shared spaces, kept her head down, and stopped trying to control conversations. When people did speak to her, it was polite but distant, the kind of politeness reserved for someone you no longer trust. Court has a way of clarifying character. I was later asked, more than once, why I didn't countersue. Why I didn't go after her for legal fees, stress, or reputational damage. The truth is simple, I didn't need to. The outcome already said everything that mattered. The judge's dismissal was permanent. The facts were on record. And the community had seen how quickly false confidence collapses when it meets accountability. That was enough. The bear never returned to that trail. Wildlife officers said that once the food sources dried up and human activity became predictable again, the animal moved on, as they usually do. Nature responds to consistency. Chaos attracts danger. Responsibility restores balance. There's a lesson in that. This was never about winning an argument with an HOA member. It wasn't about ego or proving someone wrong. It was about a line that shouldn't be crossed, ignoring clear danger and then blaming someone else when reality pushes back. Warnings aren't suggestions. Signs aren't decoration. And lawsuits aren't reset buttons for bad decisions. In the end, no dramatic apology came. No public acknowledgement. Just a quiet retreat from a fight she never should have started. The system worked, not loudly, not vengefully, but firmly. And that's the part people remember. Not the shouting. Not the lawsuit. But the moment when facts, documentation, and common sense closed the door on a narrative built on denial. So if there's one thing this whole mess proved, it's this. You can ignore reality for a while. You can even try to sue it. But sooner or later, reality answers back. And it doesn't care who you think you are. It just stands there, like a warning sign you should have read the first time.